Hi, everybody. This is Steve Hodgson from Modern Asset Management, and I'm here with Dion DiPioli again from Security Exchange Systems. And we're here to talk about collateral files, what to expect in chain of title, and the differences between types of titles. Yeah.
Lost your mic there, Steve.
You did. You lost my mic there.
I can hear you now.
Okay, now I'm back.
Yep.
So, let's go. I'm going to stop screen sharing and let you take it from here.
Okay. So, what we're going to do is we're going to respond to. Well, I'm going to read some questions from somebody in the tribe here that had reached out to Steve and I, and I think it's. I think there's some value in the questions that were asked and the answers. So Steve's going to give some answers first, and then we're going to talk about those.
Double correct me.
Yeah. So there was an incident for this particular investor where they had purchased a loan file, and they had obtained they thought they were purchasing a loan file, and it turns out that loan ended up being a contract for deed. It was not a mortgage or a deed of trust or a security deed, state of Georgia.
Mm-hmm.
And so they were teamed up with someone, and there was some due diligence taking place, and there was some misunderstandings, which is very common, very, very common when it comes to land contracts. And so let's just start there.
Yeah.
So Steve, a land contract, if you were to help us understand what those are, what is a land contract, and why do they keep getting referenced as notes?
Well, so it's a land contract, also called a CFD or a contract for deed, was promoted to me to be a shortcut to foreclosure with the borrower. So it was hyped as a way to circumvent the foreclosure rules and take possession of properties faster than going through the long process. So a contract for deed is the same as leasing a car. You own the car, sure you do, but you don't get the title until you've made all the payments. And that's the way I understand that. What you do earn as the renter / borrower or the lessee is you earn all the equity upside that happens in that property since you bought it, which is the reverse of leasing a car, which becomes worth less and less every day.
Yeah. So while I comment there, Steve, see if you can go into your options and do the same thing that I did. Just turn off the automatic adjust on your microphone, because it's a little so anyway, I would describe a land contract. Well, first off, it's an installment contract, right? So if you go and you put something on layaway, you're going to make payments to fulfill the total purchase price, and at the point in time that purchase price is fulfilled, then you will take full legal ownership. During the term of the contract, you have an equitable ownership. And we use that example as tenants, because tenants have an equitable interest in the real property. Tenants do not have a legal interest in the real property. So the buyer in a land contract, contract for deed, bond for deed, they go by a couple different names. It's not the same as a mortgagor or a borrower.
Mm-hmm.
And because the mortgagor or the borrower actually has legal ownership of the property. To rewind one step there, the act of getting a mortgage is actually saying it wrong, because a borrower doesn't get a mortgage, they give a mortgage, right?
Right.
So I give the bank a mortgage,
Mm-hmm.
and the bank gives me money. In a land contract, the owner is still retaining ownership. and there is a installment contract that does, there's a contract to purchase it, and sometimes that's referred to as the note. But what happens is I think a lot of newbies, they're always hearing this generic term note, and they assume that all promissory notes are the same, and that's obviously not even remotely close to being true. And so we have to start there. We have to understand that the interest in the real property is different than it is when it comes to a mortgage or note. And from there, we can build to understand what we should be looking for. Because when you purchase a land contract, you are not purchasing a security instrument. A land contract isn't a security instrument. It is an installment contract, and you are purchasing the real property. And so
who
that's
owns the property? Who owns
purchasing the real property that has a land contract to it.
Okay. Now, it would seem that if I was buying real estate, in most states, I'd have to do that through a registered real estate agent or broker.
Yeah. That's the way that goes.
I've never, ever been approached by a licensed real estate agent or broker in any, here in California. The person that sold me a harbor portfolio loan was certainly not a South Carolina real estate agent or attorney.
Yeah, broker beware. So as you know, Steve, I am a licensed real estate agent. And you and I have had this discussion before of some of that being a little bit of the wild, wild west. Broker beware. You are showing those around, and you are acting like a real estate agent, because the buyer buys real property, and it's residential real property typically. And in most states, you have to have a license to do commercial as well. Yeah, you're going to get yourself in trouble. So real estate.
I could sell a CFD, or I could sell a land contract, and without having to go to real estate school or pay licensing fees or any of that silly stuff.
No.
Oh, okay.
No, that would be against regulations in all 50 states.
But Uncle Dion, other people do it.
Yeah, no, not really. and this is the difficulty, right? Because I think a lot of people are passing those around as, it's a note, and so I should be able to treat that as like a, some sort of, debt instrument and security, right?
Yep.
It's not that at all. And if we understand that that's the jump off point, then everything that actually follows in that instrument, the contract or deed, starts to make a lot more sense. And the due diligence as such is significantly different. Well, not significantly, but there's some parallels for sure, right? You've got somebody who is obligated to pay you over time, and you have concerns about their income and their assets and what sort of down payment they made. There's some resemblance to an extension of credit. However, there is, at the end of that contract term, there are obligations that you, the property owner, has that need to be fulfilled to convey the deed to the purchaser in the contract, right? So it's like, it's like a lease option in that sense. If they execute the option to purchase, you've got to follow through and convey clear marketable title, which leads us into the next set of ideas. Oftentimes, these, land contracts had become, they were very common in the past, and every state has a different view, and that's important.
And they're still fairly common across the Southeast.
Yeah, and they've come back in notoriety or popularity, I guess is probably a better way to say that. So, and a lot of that probably stems from, some of the credit crunch that came up, and and look, land contract is a viable way for you as an owner to sell your property over a term and earn some interest on it, right? You already own it, and you can sell it. And if you're an owner, and let's say that it's not owner occupied property, you have a loan on a property from a conventional bank, you're technically not alienating the bank because you haven't conveyed it yet. So, and if you don't understand what that means, it's the proverbial due on sale clause, because conveyance is a future date at the point in time that the terms of sale are completed. Once you pay me every last penny, I'll give you title. And until I give you title, I haven't alienated the bank, which is the concept of due on sale.
Right. So the bank maintains their first position. You're treating the transaction as like you said, a lease or a rental until the balance is paid.
Yes. Yes.
All right.
And now,
so then why did I have so much trouble with my contract for deed that I bought? Oh, that's right. It wasn't recorded properly.
Yeah.
3 times.
So, and so again, so local jurisdiction starts to dictate some things here too, right? So in most states, you're going to find that there is a requirement to record that contract for deed, because that gives constructive notice to everybody that's involved that this is an agreement, right? So you're saying to the world, hey, look, Dion is going to buy Steve's property from him over the next 10, 15 years at whatever, 10% interest. And at the point in time that he completes that successfully and makes all those payments, Steve's going to give him a warranty deed.
Mm-hmm.
Dun, dun, dun. The problem now stands that you probably didn't get a warranty deed when you bought the property.
No, I did not.
Yeah.
I got something called a quitclaim deed, which I thought was just as good.
Yeah. So there's 3 types of deeds. One is a warranty deed, and that warranty deed is the best deed you can get. A warranty deed is a deed that the seller warrants the entire history of title, and by warranting that history of title, they agree to stand and fight with you if any previous claims were made. And that coincides with title insurance that you get, and so on and so forth. But that warranty would go back all the way until the point in time that property was actually annexed into the state or the United States. There was actually a joke floating around the internet one time. I always like to tell the story, where an attorney responded to a title inquiry where he did take the title history all the way back to the Louisiana Purchase. And that's literally what you're doing, right? That's the warranty. That's what you're agreeing to do. So that's deed number 1, right? So that's the best deed you can get. And in most states, there's a requirement that if you enter into a land contract for deed, or deed for bond, or bond for deed, that you as a seller have to deliver a warrantable deed to the purchaser. You cannot deliver a lesser deed. We'll come back to what that means in a second. So the next type of deed is a special warranty deed. And special warranty deeds are a deed where the owner of the real property only warrants the time of their possession. So in other words, the previous history before the current owner is no longer warranted. These are common deeds when dealing with REO. So when a bank forecloses for as a limitation to their liability, they will often issue a special warranty deed, which says, buyer beware. We'll warrant the term that we owned it, but whatever happened before that, that's on you and your title insurance. Don't come knocking on our door to defend me. There's some other scenarios that you'll see those used, but that's probably the most common as bank doing an REO. And then the final is a quit claim deed, QUIT, which often gets enunciated quick. So for those folks that ran around for a little while, right? So it used to be the quick claim deed because it's the deed that happens the quickest, right? And so it is literally a deed that carries no warrants with it, and literally it's all in the name. The grantor, the person that's giving the deed, is quitting their position. I quit, and the grantee assumes that position.
Mm-hmm.
Right? So for any liability, any potential claims, if you are the buyer and you're the grantee, you step into those shoes, you assume all that liability, you have to deal with all those claims.
Right. So if I have a quitclaim deed and I think I have a real deed and I think that I can get title insurance, well, we can't do that. And I think I'm in first position. I'm not, because anybody in any county, city, state, IRS, anybody who is going to try to attach the property against the prior owner or the prior owner or the prior owner, depending on when they last recorded something, can get in the way of me taking full ownership of the property, right?
There was a couple interesting terms that you used there that we're going to go clean up.
Uh-huh.
Right?
Yeah.
A quitclaim deed is a real deed. There's 3 types of deeds. It's one of them, right? So it's not a deed. It's just a deed that doesn't carry any warranty with it. It does not give you any protection from any previous claims. Oftentimes it is uninsurable, or you will have to do additional things to insure your title. So there's a couple of conditions there, and that's just going to depend on whoever your title insurance.
Which I define the couple of things as writing checks to an attorney in South Carolina, who produced a beautiful piece of paper that said warranty deed.
Right. So and that's often what happens. So a lot of times. It seems in the market right now that there's a lot of property that sort of comes by way of perhaps like a tax sale, right? And in many jurisdictions, it's a requirement that if you purchase a property at tax sale, that you quiet the title.
Oh, let's leave tax deed and tax lien for another session, because we can dive into that forever.
Right. But the point there is. Obtaining a quitclaim deed may require you to go back and quiet the history of title. And that, that's $1,200 that you're going to spend, and could take up to 90 or 120 days legally. So you'd hate to be the seller in a land contract, get all the way to the end of that term to find out that you now are breaching your own contract, that the buyer can come after you for damages on because you're not capable of delivering the deed on time for the contract that you purchased.
Right.
So you're stepping into some liability by not understanding what you're supposed to really have. So the takeaway there is that it's not a bad thing to buy that land contract on a quitclaim deed, but just understand the next couple of steps that you're going to have to take. And look, and obviously if it's 10 years, you got a minute, right? Use a couple bucks from the payments, get quiet the title, and and all of a sudden you're ready to take care of the issues that.
But if I'm playing in the lower end pool of land contracts that are trading at $10,000-$20,000, and I've done my modeling based on that, my all-in number, suddenly I've got a $1,500 attorney bill to get it cured, and that kind of throws a wrench in the works when you're 15% off.
Yeah, we're working on a pool right now of 50 of those in a city that is of lower bandwidth collateral. And yeah, look, you start buying stuff at call $10,000 a door, and you start putting 10% on top of that.
That's right.
Start eroding your return real quick, right? So you got to know what you got to do, because that kind of thing pops up, and it's obviously not a good thing. But so and again, this stems from understanding that you bought the real property. You didn't buy a secured interest in the real property. You're literally the owner of the real property. You are literally responsible to deliver this deed on this installment contract. And if you don't, there's damages that you may have to pay to the purchaser in the land contract.
And this is something that the CFPB has taken a hard look at. They've assigned some staff to go chase the contract for deed business. There have been a couple of the larger funds that have been told to liquidate, which is why this paper is suddenly in the some of this paper is in the marketplace. And there's some, when the CFPB finds somebody, the fine's in the millions.
Yeah, so just to kind of address that briefly. You know, as you mentioned when we first started talking about them, is they're often used as a circumvention of foreclosure. And again, so it's going to depend on the state that the instrument's you know, written in. But you know, in most states, there's a point in time, whether it's immediate through principal reduction, or you know, the combination of the two, where a borrower earns the right of redemption. So when the I'm sorry, the purchaser earns the right of redemption. That's and so that's when it starts to look like an actual deed of trust or a mortgage, and you have to actually foreclose because they've earned a right of redemption. Prior to that, there's generally the idea of forfeiture, and so forfeiture's, you know, an eviction. And so what the CFPD is looking at is the abuse of that, and they're saying, hey, you know, you're sticking people into these things. They're, you know, they're glorified renters. You're trying to essentially pass off all the liability of the real property onto them. They probably shouldn't be in that position. Or for instance, you put them into a property that isn't repaired. You know, there's a lot of things that go into that.
It's not habitable. It's people use it to avoid the ability to repay rule.
Yeah, right.
Let me get $1,000 down, $700 a month, and everything will be happy.
Right, right. And I think if I've, you know, I believe the one that you had that you first started with looked a lot like that, right? It was a dilapidated property that the guy got into, and he was like, "Yeah, what do you want me to do here?" You know, this.
That's right. There's a hole where the roof should be.
Right. It's usually a problem. So yeah. So again, so you know, the underwriting or the due diligence there is different than it is in a typical mortgage or deed of trust. So then carrying on in the same idea here, right? So the additional commentary was this particular set of due diligence that was being conducted on the land contract, a full E&O, which is an encumbrance, ownership and encumbrance report, O&E, at the time was purchased for due diligence. And that became a problem. So they're looking at this O&E, and they didn't understand the requirement within the land contract to deliver a warranty deed. So the O&E is showing you who the vesting's from, which is, you know, should be your seller. And so I'm just going to read this for a second. So I'm buying full E&O report at the time of purchase. Contract has seller providing warranty deed and representing the title is unencumbered except for taxes and prior disclosures. Contracts would be a good discussion. The seller's going to modify contracts for one-off buyers, but an explanation of what are we getting into would be of value. Level of deeds was a wrinkle I hadn't thought about, even though I know that you have to perfect the tax deed. Just didn't think CFDs are the same issue. So just take that first. Let's take that first. There's a trap here. So one more time, the buying full E&Os, right? This was, oh, I'm sorry, this was actually this was your commentary back. Contract has seller providing warranty deed and representing the title is unencumbered except for taxes and prior disclosures. Contracts would be a discussion, but sellers aren't going to modify contracts for one-off buyers. I think what's being talked about there is actually the contract for deed. And so the takeaway there is there's actually nothing wrong with the contract for deed. It's operating the exact way it's supposed to.
Yeah.
So I was reading from the wrong place in the email. So I think the only thing that I would want more information on is the title report and the collateral file. I'm a bit confused about what's in the title report and what we should be looking for in a title report, which we're going to come to.
Well, and I should be, I think I'd like to point out for sure that there's different levels of title reports, and title reports are not title insurance, and O&E report is not title insurance.
Yeah, there seems to be some gross misunderstandings of what's going on with these things. So for example, one of the notes that I purchased was a contract for deed, right? So this investor made that mistake. Along with the purchase was a quitclaim deed. There we talked about. At the time, I did not understand the difference between a quitclaim deed and a warranty deed. It wasn't until I got more into it that both and the other note investor that had been partnered with really wanted a statutory warranty deed, which there's no, I mean, the warranty deed, which we figured out too late in the process to go back, and the seller had to sort of go back and get all this stuff cleaned up from the sell side, right? They'd purchased the asset. They're in the middle of it now, but their seller had quit. They had stepped in, and now they're figuring out that, hey, we're the ones that have to clean up title now because we're obligated under contract.
Yeah. You signed a contract that said that you would accept a quitclaim deed.
Right.
Yes, I did.
Yes. So then we get to the perception of the issue with the E&O report, which was there was a problem with the ownership and encumbrance report through the company that it was obtained from. It seems that years before, someone had an ownership interest that did not appear in the ownership and encumbrance report because it was well before the date that the O&E picked up. We had to initiate a quiet title action to suppress the possibility that one of the heirs would come back with their hand out and make claim to the real property. Again, it did not appear in the O&E report that was paid for the due diligence. So the question would be, why did that happen? Or how did we get there? And would that be the common case?
Mm-hmm.
I'm gonna wait for you.
Would that be the, well, yeah.
There's a trap here again.
Yeah, well, because it's a public record search. It can be flawed by what's not recorded at the county level. Not all of these counties, particularly the rural ones, are all digitized. There's all manner of stuff that go wrong, and it's not insurance. It's information that's public that they compile from publicly available sources, and you agree that you know that.
So
what's the hook?
So if much of the tribe has done some reading of my commentary on Bigger Pockets, this is the part they like, where I just come in and drop bombs on everything you said, because none of that's really accurate. When you get an O&E report, whenever you search title, if the county is unavailable online, someone literally goes to the courthouse.
Right.
And that's the case for any title work that's done. So whether it's searchable online or you have to go there, just assume that they're doing the right thing. An O&E report is usually back to one owner. So it's the last deed that was recorded. And so that's not the same thing as a search that's done for title insurance, which is usually, a 50-year search. In other words, they go back 50 years and make sure that there's no defects in title that may arise. And oftentimes, this is why I had to bring up the tax deed thing. Oftentimes, those historical interests may have a right to come forward and make a claim on the real property, even though taxes foreclosed on real property. And so that's why you're quieting all those historical voices. But in the O&E report itself, understand that when you go get an O&E report, which is oftentimes used for the purpose of purchasing a mortgage or a deed of trust, not purchasing real property, right? So you're assuming that there's an owner, there's a proper warranty deed at the point in time that there's the last owner purchased at the grantee, who is now your borrower, purchased the property. They got a warranty deed. There's title insurance that already did a proper 50-year search on title that is now insured. And then the lender, which is the lien or the security instrument that you're purchasing, also ensures their priority in title to be whatever lien position they are, first or second or third, whatever, right? So again, understanding that it's a completely separate thing, right? One is real property, which to purchase real property, you go back in time and you get title insurance, and that title insurance solves some of these problems. When you purchase loans, you go back to the current borrower because you're piggybacking, you're jumping off on what was the last purchase that the borrower who gave me the mortgage, who gave you the mortgage, gave the lender the mortgage. That's what you're validating, right?
Right.
And so the O&E can be a valuable tool in a purchase, when you're purchasing contract of deed, but only so far as it tells you that whoever the current owner is, who created or holds the contract for deed, what's happened since they took ownership. That's it. But you're going to purchase the real property, so you need to understand what took place before that, because that's where the historical defect may occur, and that O&E will not show you that. And that's not because it's not because there's some problem with it. It's you use the wrong tool. You use the wrench to try to pound in a nail. So it's the wrong thing. And so so oftentimes I would suggest, I'll give you an example. Again, we're working through a portfolio of these right now, and so we had to go to a title company that we do some business with, and I had to work through this. Right, you guys do the searches, you give us. So they're doing a pseudo O&E for us so that we can run through due diligence and feel comfortable. Then we're actually putting a blanket policy over the entire portfolio, and we're paying a reduced rate for that. But there's still a 50-year search that comes in post-purchase. So we're using the O&E as a driver to accept or reject assets into the trade. And really what that's going to tell us is there any new municipal liens? Has what's popped up since ABC company had this thing that we need? Is there taxes current? Are there municipal liens? Is there some other issue on title since they took ownership? Once we get past that, because those are all the issues we can deal with from them. Once we're past that, we say, all right, this is the group of assets we're going to purchase. And we turn back to the title company and say, all right, now we're going to pay you some more money. Here's another couple $100, and you're going to finish doing the 50-year search, and you're going to then insure title. And then we'll have insurance on all the assets in the pool, just like you would in any real property transaction anywhere in the U.S. And that's the way it has to look, right? Because again, it's not a loan. So what seems that I think is so unfortunate.
Hang on a second. Your screen is frozen.
Minus. Oh, I can't hear you.
Oh, now you can hear me?
I can hear you.
Okay, now I'm back. All right.
Yeah, that might have been, you might have just.
Yeah, I was trying to stop my video, not stop I stopped the audio instead. All right, so much for professionalism.
Now, you just changed your picture somehow.
Yeah, I'm trying to reduce my bandwidth by instead of having my feed go the whole time.
Oh, gotcha. All right, so, well, what we were going to show was one of these O&Es. Let me take it. I'll take the screen.
Okay, take the screen.
So here we go we looked at this last time, as soon as my screen cooperates with me. So this is what it looks like when we set up a due diligence file, right? The standard structure, we kind of talked about this last time, right?
Mm-hmm.
So we have, in this particular pool, this is an asset that Modern Asset Management does. So we have our title report here. This is the title report that we ordered for due diligence. It actually says V2 because this may be shocking, but just because you ordered an O&E doesn't mean it's accurate. Sometimes you have to get them updated as well. So, and these are skills that newer investors aren't going to have. You're not going to know this stuff. This was something that we picked up. There was an error in the report because as we went through the file, we were like, hey, wait a minute, this is missing. This needs to be in there, and so we had to go back and have the title company update the report, which they did, in short order. But the story here. So, we're going to use this is from ProTitle, who, by the way, love ProTitle's work. They do really good work. They take care of us really well. And they're, the cost.
Okay, so let's back up and just cover that again. So this is ProTitle USA. This is a digital digitally based title company. They're kind of an upstart in the business, and they do all kinds of batch kind of work and things to try to make things move faster.
Yeah.
So,
Yeah, and so that's a good point too, right? There's different levels of search that you can get, right? O&E is just one of them. You can do higher level, quicker, cheaper searches that, it depends on what you're looking for, and depends on the purpose of the report, the utility of the report, I should say. So this particular asset we have. This asset was finishing up in foreclosure. It's actually, just last month, just this month it foreclosed. So as we go through this, right? So we're going to talk about, what are we looking for, right? So the first thing that we're going to look for, which is, you'd like to think is common sense, but we need to make sure that the vesting here matches our security instrument, right? So Willie Parks should be our borrower. Willie Parks et al. Should be our borrower. That's if not, then we need to figure out what happened, right? If it's someone else, if we have someone that's different, we need to figure out if they if they have given it to someone else. So our borrower needs to match grantee. If our borrower matches grantor, right, that means that they sold the property to somebody else, and you have an alienation title there. You have a due on sale clause. And so this is going to tell us what kind of deed we have to, right? So the deed that was used to convey title was a warranty deed, right? So this is good, right? So that's what we expect to see. If that was a quick claim deed, we might have some worries, right? So next portion of the report is going to start talking about the open mortgages. Usually starts with the first lien. We're often purchasing first lien, so this is the meat and potatoes of what we're looking for. So it's going to give us the borrower. Again, you can match it up, the date of the instrument, when it was recorded, the book page or instrument number, how this is referenced, how that security instrument is referenced in public record. And I just want to pause there because I just want to go back to the generic use of the term notes in this industry. Oftentimes when people say, what do you do? And I'll say, well, we buy and sell whole loan mortgages. It's only been dealing with sort of the ever loved street level investor that I started using the term note.
Okay.
Notes has become this common generic term that there's all kinds of notes, right? Reach into your wallet and pull out a dollar bill. That's a note. So understand that the term note means a lot of things, and you don't buy a note without buying a security instrument. You're really buying the mortgage or the deed of trust, and the note comes with it. And there's actually a legal reference there that that one can't exist without the other. If there's no note, there's no mortgage, right? You can't have a debt that doesn't exist secured by something. So anyway, so we'll go on. So we're checking to make sure that this all matches our security instrument, which you'd find in the collateral file, right? And then we'll get into, and then typically what you're going to have is you're going to have the chain of assignments, right? And this is the succession of the assignments of mortgage or assignments of deed of trust that are recorded. And so there's two things that you're going to get here, right? There's going to be an allotment or endorsement, which we talked about last time, and then there's going to be the assignment of mortgage. So the assignment of mortgage is what is conveying the legal interest of the security instrument, which is an equitable interest in the real property, right? That's what that is. So we have the original lender and who they, who they conveyed to, and we're just kind of follow this along. And so I said this last time, it's really, if you just kind of go into these things and you just, look, you don't need to overly examine this in the sense of, here's the date, there's the instrument, they already did that work. What you want to know is who's the person they gave it to, right? So who got it, who'd they give it to, right? So we see here BOA to Carrington, and then it follows that Carrington must be the next assigner, right? So OR is the giver, EE is the receiver, right? So if you don't remember that, I always think borrower, right? Your borrower is your mortgagor, right? That's the way that I always think about it. So anyway, so Carrington, so BOA gives it to Carrington, Carrington gives it to HUD, which is, that's HUD. Then HUD gives it to Wilmington, blah, 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 blah. Now, a lot of people, they see these things, they get all confused, right? So let's pause there. Let's talk about what this is. Steve, what you tell me, what is that? What is this thing?
Who is that? Okay. So Wilmington Savings Fund is a federal savings bank doing business as the Christiana Trust, solely in the capacity as owner trustee of whoever Mattawan Ventures is, and that's the special purpose vehicle that bought these HUD home loans, and it's assigned for diligence. It's assigned for processing to Condor. So how wrong am I?
You're really there. I mean, so it's the trustee of the Mattawan Ventures Trust Series 2016-4, which is the single purpose entity, which is often formed. That's how bigger funds invest. That's how loans get securitized.
So I'm now in the world of mortgage-backed securities and derivatives and all of that. And so.
Well, we don't need to jump into derivatives, right? Don't start scaring everybody. But this is certainly a pool of mortgages that probably was intended to be managed as a vehicle for investment. Whether that was intended to be securitized formally or just managed as an investment, we can't know. Oftentimes you'll see these higher up in the chain. So if we were to see something like this, all this blah 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 coverage, and something trust series with a bunch of numbers, that's typically a good sign that the loan was actually held in security, and then you'd see it come out and then flow to a couple of the a little bit more familiar names.
Right. And some of my loans that had activity back in 2005 that I bought. I see them coming in and out of Lehman funds and bouncing around as they got repackaged and resold.
Yeah, right. Yeah, it's not uncommon for it to be in one securitized pool or one single purpose entity or vehicle and go to another for various purposes. So that's what that is. Don't let it scare you. It's just one entity with a big long name. And then the care of Condor. So Condor was this particular was in charge of this particular pool of assets. So that's that. So it that's I'm showing us the next page so we can see that portion's over. So as this stands, this entity literally should be the entity in our purchase contract. If it's not, then you are missing assignments.
Right.
If these do not follow each other, then you are missing assignments. And when I say missing, those assignments are not of record. Is it okay if those assignments? So let me ask you a question. Do you need to have these in the file now that they're recorded?
In order to have standing in a foreclosure action, you have to prove the ownership chain, and you have to prove that it's intact.
Do you need to have these assignments in the paper file? Do I need to have a digital copy in my little collateral file right here and see that they're in here?
Need is not the correct. Is not the correct desire. Desire, yes. Need, no. It's what's recorded that matters.
Yeah, I would even tell you that there's no desire to have them. Once they're recorded, the utility sort of expires. They're of record. They're never going in.
So when a year ago when I bought that basically two banker boxes of loans, I spread them all out on my conference table, and I matched up every single piece of paper to the to the title reports. You saying I didn't need to do that?
The colossal waste of your time.
Okay. Well, I touched a lot of paper. Yeah, right. And as I'm like, like into 20 of these, I'm like, I bet I'm just spinning my wheels here.
Yeah, no. Kudos on the effort, but colossal waste. No, anything that we see here, this is what this is. This is a public record. It's not going.
And I'll say the learning exercise there, the
Is there what?
reading every single document in this loan through loan modifications and all that stuff was very educational for me. But the last 3 I bought, I didn't even look. I just put them in the drawer.
Pays to have somebody that knows how to do diligence.
Yeah.
That said,
That would be you.
So there's, again, you don't have to have a copy of the mortgage in your file either, right? If it's recorded, it's recorded.
Mm-hmm.
So if you need a copy, or foreclosing attorney needs a copy, they'll pay the $25, $50 or $10, whatever, and they'll get a copy from public record. That's a certified true copy.
So that is the system of record. It's the governmental recording that is the system of record, not what's in your file cabinet, not what's in the file.
Right, for these,
Mhm.
once they're recorded.
Mhm.
Now, if it's not recorded, if we're missing one, this is not your seller, or we determined that there's somebody that isn't in this chain, there's a skip, right? Then now you need that because you have to record it.
Mhm.
So if I'm missing something between Carrington and HUD, right? I guess let's say Bank of America and HUD, which I'd be missing an assignment to Carrington, right? So this one would be missing. This is an intervening assignment, and you would have to get that AOM either from the seller's file, or you have to go get the AOM from Bank of America or Carrington, have them recreate it, send it in as an intervening assignment, which means this is out of place in time. Please record it, and you'll reference where it belongs in time.
Mhm.
So, speaking of AOMs, so that's an intervening assignment, right? So those used to trouble a lot of people. Most chains are pretty, it's really been a long time since I've really had to well, I guess it depends on the quality of your seller and the loan files, but it's been a long time since we've had to clean up missing AOMs. We still have recording issues.
Well, what I've seen is when you've got a fund manager who takes in assets into fund number 1, they close that fund down, it moves over to fund number 2. They may not record those internal transfers inside of their books. Right. And you've got to, and we fill out, we get the assignments, we get them all signed, and we put a sticky note on each one that says file first, file second, file third. And I haven't had a file fourth yet, but I've had a file third.
Yeah, and then you ship them off to find out that they're formatted incorrectly.
That the forms are wrong, and that the checks I sent in were wrong too. Yeah. Regardless of what the county website says, you got to call and find out what the fees are.
Yeah, it's frustrating. So, and so that would be a good example of what's missing at the tail end, right? So ABC Fund 2 is your seller in contract, but they're not the last person in the chain here. So you're missing the tail of the assignment, and that may be a function of the way that the seller held those loans. And you just need to get them. That's all. You just get them and you send them in for recording, right? So this is who's in your contract. That's what you gotta take a look at. So that's the story of assignments. It's not any more complicated than that. I know people freak out and they create. One other thing, because I had another particular situation. The assignment itself is not your legal standing to the loan. It is your constructive notice to the world of your ownership.
That I'm here first.
Yeah. So if you have an issue with the idea of owning the loan, that is a function of your purchase and sale contract. So in other words, if I sold you a loan and there was some disagreement to whether I sold you that loan, that's a function of the purchase and sale. That's not resolved through the assignment. The assignment is evidence to the idea But I think sometimes, I think newer investors put a lot of weight on assignments, and they forget that there's this whole contract that's 10, 15 pages long that talks about what was happening, what was being delivered, how it was being delivered, everybody's responsibilities, the fact that you own it, and all of that. And that's, the moral of the story is, the takeaway there is, don't overlook the function of the purchase and sale contract, because that's where the real meat and potatoes comes from. The assignment is a byproduct of that.
Right, my primary work is unsecured, and I buy and sell unsecured loans, and it's the purchase and sale agreement is all there is.
Right. Yeah. Yeah.
It often it'll be a spreadsheet.
Right.
All I'm buying is a spreadsheet. There's no box of files ever.
Right. Yeah, and you want to, if you think you're getting scared when you're buying a secured loan, right? You get satisfied when somebody just sends you an email and says we're done.
That's right. That's right. All right, so back to the title, just to run through the rest of it.
Yeah. So generically, this is going to be property dependent. So this particular one, there's, some other active liens and judgments going on. So this is, there's a Capital One lien, right? Unsecured lien, which we were just talking about. This looks like a civil, there's a civil judgment from a particular person. There's no consequence if you're in first position, provided these are filed after you, then you shouldn't be an issue. And if you're buying a conventional loan, I would tell you logically, that loan wouldn't be originated if these stood, had any, were existing prior to this, right? So then there's usually going to be some sort of semblance of what's going on with taxes. They do a good job over there of telling you what's paid, what's not paid. Sometimes you got to check on, what does it mean if there's something due, there's something past due, and whether or not that's a certificate, and when that foreclosure potential may occur. That's going to be jurisdiction specific. Call and ask the county. Assess value, and then the rest of this is going to be, I think too, I guess the rest of this is where we're going to get into just the supporting docs, right? So, this may be shocking, but if your file does not have a warranty deed, or your file does not have a copy of the mortgage, here it is. Or remember those AOMs that you laid out? Right. Well, here they are, all nice and neat for you. It's the same thing that you did, right? Let's find out the loan mod. There's your recorded loan mod. I don't know, they're in here somewhere. So moral of the story is, if something pops up and you're missing something from file, the point of getting these O&Es is to use what's in them, right? It's already organized for you. And that's why we don't, so if you look at the way that we do due diligence here, we literally just pull these things out and shove them in here. And we don't spend a bunch of time with them. We see what's there, and we really peel through the allonges or the endorsements, make sure that those are in place. But the assignments, we use the title report, and if something's missing, we'll go through here. And I think that was actually what took place. There was an intervening assignment that was missing in this particular report, and so when we went back through what was in file, we identified that intervening assignment, shot it back over to ProTitle, and updated the report. And sometimes that happens. Sometimes there's human error. It's not a perfect world. This isn't automated. This is somebody literally looking through images to make these reports. So I think that's soup to nuts, right? We talked a little bit about difference between land contracts and mortgages and deeds of trust, and we dug into the idea of what is this O&E report? How does it work? How do we use it? What's on it? And so obviously the takeaway there is make sure that you're using the tool for the job that it's supposed to be used, and don't and don't assume that it's for some other use. And I think that's this confusion, right? Because there's a lot of what I like to call barroom banter that goes on, and everybody's, oh, did you get your O&E reports? And you said that just so that you could make it sound like you actually know what you're talking about. But then once we start to peel the onion back, you don't even know what an O&E report is. And if you don't know, look, that's why we have this group, and we love to have these questions come back at us when we do.
Absolutely. No, it's being brave and putting out what you don't know is what helps other people that are too shy to ask the question. the most dangerous thing, the most dangerous type of decision you can make is one that's founded on so-called unconscious incompetence, and not knowing what you don't know. And well, that's you know, that's
Right.
that's me.
Yeah. And this is, again, this is one of those things where you're spending so much time around potentially other, maybe newer investors, right? You're not hanging out in the room with all the experienced guys because it's more comfortable over there with the newer guys. And there's a level of information, and sometimes you all might be headed in the wrong direction. You all might not understand what it is you're talking about. And I've commonly referred to that idea as you don't know what you don't know. And the way that you do know is you either ask or you break something and it costs you some dollars, and now you're going to find out, right?
That's how I learned about unrecorded warranty contracts for deed and quit claims and all that.
Mm-hmm.
I wrote a check to an attorney, and then I paid attention.
That's right. That's right. That's the way to do it.
I remember when you and I were just starting to talk after I found you on Bigger Pockets, and I sent you over this file that I had just bought, and you just went off the hook about get out, and I was like, dude, it's too late.
It's a trap.
Well, and it absolutely was. It
Yeah.
absolutely was. So but oh well, so it's either I was going to pay to go to school or I was going to pay to go to school. So
we got you out of those, though. You're into bigger, better,
yes,
better assets.
I'm now doing whole loan mortgages.
There you go. See, it just sounds so much cooler too. Like,
That's right.
it's like, what are you, a secretary?
So I want to go put a tie on. So.
Yeah, sounds so very sophisticated.
Okay, so I appreciate this. I'm heading out on the road next week, and I'm going to send up some stuff from looking at some single-family property rehab work I've done in Pensacola, and share the pieces of that, because I think what's relevant to this group is that I'm writing seller finance contracts on those, and we can talk about marketability of seller finance contracts.
Yeah, a lot of people ask that question. Yeah. Which also ties in with this idea that you can buy the non-performing loan, save the borrower and save the world, and sell that loan for to become a Fortune 500 company. Probably like 6 months or something.
Yeah, so we should have talk about that. All right, so I want to apologize to the group for the static coming from Dion. We've had this little wrinkle that sounds like paper come and go, but we do our best.
It's my electrifying personality.
That it is. And you and I'll talk from Pensacola. We'll turn the camera on again and tell us what's going on there.
Perfect.
Okay. All right. Thanks, everybody. Bye-bye.